Article 114. Treason. Any Filipino citizen who levies war against the Philippines or adheres to her enemies, giving them aid or comfort within the Philippines or elsewhere, shall be punished by reclusion perpetua to death, and shall pay a fine not to exceed 4 million pesos. No person shall be convicted of treason unless on the testimony of 2 witnesses, at least to the same overt act, or on confession of the accused in open court. Likewise, an alien residing in the Philippines who commits acts of treason as defined in paragraph 1 of this article shall be punished by reclusion temporal to death and shall pay a fine not to exceed 4 million pesos, as amended by RA 10951, August 29, 2017. Article 115. Conspiracy and proposal to commit treason. Penalty. The conspiracy or proposal to commit the crime of treason shall be punished respectively by prison mayor and a fine not exceeding 2 million pesos, and prison correctional and a fine not exceeding 1 million pesos. Article 116. Misprision of treason. Every person owing allegiance to the United States, open and close parenthesis, the government of the Philippine Islands, without being a foreigner, and having knowledge of any conspiracy against them, conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province, or the mayor or fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. Article 117. Espionage. The penalty of prison correctional shall be inflicted upon any person who 1. Without authority therefor enters a warship, fort, or naval or military establishment or reservation to obtain any information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippine archipelago, or 2. Being in possession, by reason of the public office he holds, of the articles, data, or information referred to in the preceding paragraph, discloses their contents to a representative of a foreign nation, the penalty next higher in degree shall be imposed if the offender be a public officer or employee. Section 2. Provoking war and disloyalty in case of war. Article 118. Inciting to war or giving motives for reprisals. The penalty of reclusion temporal shall be imposed upon any public officer or employee, and that of prison mayor upon any private individuals who, by unlawful or unauthorized acts, provokes or gives occasion for a war involving or liable to involve the Philippine Islands, or exposes Filipino citizens to reprisals on their persons or property. Article 119. Violation of neutrality. The penalty of prison correctional shall be inflicted upon anyone who, on the occasion of a war in which the government is not involved, violates any regulation issued by competent authority for the purpose of enforcing neutrality. Article 120. Correspondence with hostile country. Any person who in time of war shall have correspondence with an enemy country or territory occupied by enemy troops shall be punished 1. By prison correctional if the correspondence has been prohibited by the government. 2. By prison mayor if the correspondence be carried on in ciphers or conventional signs. And 3. By reclusion temporal if notice or information be given thereby which might be useful to the enemy. If the offender intended to aid the enemy by giving such notice or information, he shall suffer the penalty of reclusion temporal to death. Article 121. Flight to enemy's country. The penalty of arresto mayor shall be inflicted upon any person who, owing allegiance to the government, attempts to flee or go to an enemy country when prohibited by competent authority. Section 3. Piracy and mutiny on the high seas or in Philippine waters. Article 122. Piracy in general and mutiny on the high seas or in Philippine waters. The penalty of reclusion perpetua shall be inflicted upon any person who, on the high seas or in Philippine waters, shall attack or seize a vessel, or, not being a member of its complement nor a passenger, shall seize the whole or part of the cargo of said vessel, its equipment, or personal belongings of its complement or passengers. The same penalty shall be inflicted in case of mutiny on the high seas or in Philippine waters. R.A. number 7659, December 13, 1993. Article 123. Qualified piracy. The penalty of reclusion perpetua to death shall be imposed upon those who commit any of the crimes referred to in the preceding article under any of the following circumstances. 1. Whether they have seized a vessel by boarding or firing upon the same. 2. Whenever the pirates have abandoned their victims without means of saving themselves. Or 3. Whenever the crime is accompanied by murder, homicide, physical injuries, or rape, as amended by R.A. 7659, December 13, 1993. Title II. Crimes against the fundamental law of the state. Article 124. Arbitrary detention. Any public officer or employee who, without legal grounds, detains a person shall suffer 1. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period, if the detention has not exceeded 3 days. 2. The penalty of prison correctional in its medium and maximum periods, if the detention has continued more than 3 but not more than 15 days. 3. The penalty of prison mayor, if the detention has continued for more than 15 days but not more than 6 months. And 4. That of reclusion temporal, if the detention shall have exceeded 6 months. The commission of a crime, or violent insanity, or any other ailment requiring the compulsory confinement of the patient in a hospital, shall be considered legal grounds for the detention of any person. Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding articles shall be imposed upon the public officer or employee who shall detain any person for some legal ground, and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties, or their equivalent, 18 hours for crimes or offenses punishable by correctional penalties, or their equivalent, and 36 hours for crimes or offenses punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed, upon his request, to communicate and confer at any time with his attorney or counsel, as amended by EO number 59, November 7, 1986. Article 126. Delaying release. The penalties provided for in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. Article 127. Expulsion. The penalty of prison correctional shall be imposed upon any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands, or shall compel such person to change his residence. Section 2. Article 128. Violation of domicile. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or, having surreptitiously entered such dwelling, and being required to leave the premises, shall refuse to do so. If the offense be committed in the night time, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prison correctional in its medium and maximum periods. Article 129. Search warrants maliciously obtained and abused in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period, to prison correctional in its minimum period, and a fine not exceeding 200,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. Article 130. Searching domicile without witnesses. The penalty of arresto mayor in its medium and maximum periods shall be imposed upon a public officer or employee who, in cases where a search is proper, shall search the domicile, papers, or other belongings of any person, in the absence of the latter, any member of his family, or in their default without the presence of two witnesses residing in the same locality. Article 131. Prohibition, interruption, and dissolution of peaceful meetings. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, without legal ground, shall prohibit or interrupt the holding of a peaceful meeting, or shall dissolve the same. The same penalty shall be imposed upon any public officer or employee who shall hinder any person from joining any lawful association or from attending any of its meetings. The same penalty shall be imposed upon any public officer or employee who shall not prohibit or hinder any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Section 4. Article 132. Interruption of religious worship. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. Article 133. Offending the religious feelings. The penalty of arresto mayor in its maximum period, to prison correctional in its minimum period, shall be imposed upon anyone who in a place devoted to religious worship or during the celebration of any religious ceremony shall perform acts notoriously offensive to the feelings of the faithful. Title 3. Article 134. Rebellion or insurrection. Asterisk. How committed. The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws the territory of the Republic of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or depriving the chief executive or the legislature wholly or partially of any of their powers or prerogatives, as amended by R.A. number 6968, October 24, 1990. Article 134-A. Coup d'etat, asterisk. How committed. The crime of coup d'etat is a swift attack accompanied by violence intimidation, threat, strategy, or stealth directed against duly constituted authorities of the Republic of the Philippines, or any military camp or installation, communications networks, public utilities, or other facilities needed for the exercise and continued possession of power, singly or simultaneously carried out anywhere in the Philippines by any person or persons belonging to the military or police or holding any public office or employment with or without civilian support or participation for the purpose of seizing or diminishing state power. As amended by R.A. 6968, October 24, 1990. Article 135, Penalty for Rebellion, Insurrection, or Coup d'etat. Any person who promotes, maintains, or heads a rebellion or insurrection shall suffer the penalty of reclusion perpetua. Any person merely participating or executing the commands of others in a rebellion or insurrection shall suffer the penalty of reclusion temporal. Any person who leads or in any manner directs or commands others to undertake a coup d'etat shall suffer the penalty of reclusion perpetua. Any person in the government service who participates or executes directions or commands of others in undertaking a coup d'etat shall suffer the penalty of prison mayor in its maximum period. Any person not in the government service who participates or in any manner supports, finances, abets, or aids in undertaking a coup d'etat shall suffer the penalty of reclusion temporal in its maximum period. When the rebellion, insurrection, or coup d'etat shall be under the command of unknown leaders, any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, or performed similar acts on behalf of the rebels, shall be deemed a leader of such rebellion, insurrection, or coup d'etat. Article 136. Conspiracy and proposal to commit coup d'etat, rebellion, or insurrection. The conspiracy and proposal to commit coup d'etat shall be punished by prison mayor in its minimum period and a fine which shall not exceed 1 million pesos. The conspiracy and proposal to commit rebellion or insurrection shall be punished respectively by prison correctional in its maximum period and a fine which shall not exceed 1 million pesos, and by prison correctional in its medium period and a fine not exceeding 400,000 pesos. Article 137. Disloyalty of public officers or employees. The penalty of prison correctional in its minimum period shall be imposed upon public officers or employees who have failed to resist a rebellion by all the means in their power, or shall continue to discharge the duties of their offices under the control of the rebels, or shall accept appointment to office under them. As restored by EO number 187, March 21, 2003. Article 138. Inciting to rebellion or insurrection. The penalty of prison mayor in its minimum period shall be imposed upon any person who, without taking arms or being in open hostility against the government, shall incite others to the execution of any of the acts specified in Article 134 of this Code by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end, as restored by EO number 187, March 21, 2003. Article 139. Sedition, how committed. The crime of sedition is committed by persons who rise publicly and tumultuously in order to attain by force, intimidation, or by other means outside of legal methods any of the following objects. 1. To prevent the promulgation or execution of any law or the holding of any popular election. 2. to prevent the national government or any provincial or municipal government or any public officer thereof from freely exercising its or his functions, or prevent the execution of any administrative order. 3. To inflict any act of hate or revenge upon the person or property of any public officer or employee. 4. To commit for any political or social end any act of hate or revenge against private persons or any social class. And 5. To despoil for any political or social end any person, municipality or province, or the national government or the government of the United States, of all its property or any part thereof, as amended by CA number 202, November 18, 1936. Article 140. Penalty for sedition. The leader of a sedition shall suffer the penalty of prison mayor in its minimum period and a fine not exceeding 2 million pesos. Other persons participating therein shall suffer the penalty of prison correctional in its maximum period and a fine not exceeding 1 million pesos. As amended by RA 10951, August 29, 2017. Article 141. Conspiracy to commit sedition. Persons conspiring to commit the crime of sedition shall be punished by prison correctional in its medium period and a fine not exceeding 400,000 pesos. Article 142. Inciting to the sedition. The penalty of prison correctional in its maximum period and a fine not exceeding 400,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end, or upon any person or persons who shall utter seditious words or speeches, write, publish, or circulate scurrilous libels against the government, or any of the duly constituted authorities thereof, or which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities, or to disturb the peace of the community, the safety and order of the government, or who shall knowingly conceal such evil practices. Chapter 2. Article 143. Acts tending to prevent the meeting of Congress and similar bodies. The penalty of prison correctional or a fine ranging from 40,000 pesos to 400,000 pesos, or both, shall be imposed upon any person who, by force or fraud, prevents the meeting of Congress or of any of its committees or subcommittees, constitutional commissions, or committees or divisions thereof, or of any provincial board or city or municipal council or board. Article 144. Disturbance of proceedings. The penalty of arresto mayor or a fine from 40,000 pesos to 200,000 pesos shall be imposed upon any person who disturbs the meetings of Congress or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or of any provincial board or city or municipal council or board, or in the presence of any such bodies, should behave in such manner as to interrupt its proceedings or to impair the respect due it. Article 145. Violation of parliamentary immunity The penalty of prison mayor shall be imposed upon any person who shall use force, intimidation, threats, or fraud to prevent any member of the National Assembly, Congress of the Philippines, from attending the meetings of the Assembly or of any of its committees or subcommittees, constitutional commission, or committees or division thereof, from expressing his opinions or casting his vote, and the penalty of prison correctional shall be imposed upon any public officer or employee who shall, while the Assembly, Congress, is in regular or special session, arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor. Chapter 3. Illegal Assemblies and Associations. Article 146. Illegal Assemblies. The penalty of prison correctional in its maximum period to prison mayor in its medium period shall be imposed upon the organizers or leaders of any meeting attended by armed persons for the purpose of committing any of the crimes punishable under this code, or of any meeting in which the audience is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or assault upon a person in authority or his agents. Persons merely present at such meeting shall suffer the penalty of arresto mayor, unless they are armed, in which case the penalty shall be prison correctional. If any person present at the meeting carries an unlicensed firearm, it shall be presumed that the purpose of said meeting, and so far as he is concerned, is to commit acts punishable under this code, and he shall be considered a leader or organizers of the meeting within the purview of the preceding paragraph. As used in this article, the word meeting shall be understood to include a gathering or group, whether in a fixed place or moving. Article 147. Illegal Associations. The penalty of prison correctional in its minimum and medium period and a fine not exceeding 1,000 pesos shall be imposed upon the founders, directors, and presidents of associations totally or partially organized for the purpose of committing any of the crimes punishable under this code, or for some purpose contrary to public morals. Mere members of said associations shall suffer the penalty of arresto mayor, restored by EO number 187, March 21, 2003. Article 147. Illegal Associations. Chapter 4. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 200,000 pesos shall be imposed upon the founders, directors, and presidents of associations totally or partially organized for the purpose of committing any of the crimes punishable under this code, or for some purpose contrary to public morals. Mere members of the said associations shall suffer the penalty of arresto mayor, as amended by RA 10951, August 29, 2017. Article 148. Direct assault. Any person or persons who, without a public uprising, shall employ force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force, or seriously intimidate or resist any person in authority or any of his agents while engaged in the performance of official duties, or on occasion of such performance, shall suffer the penalty of prison correctional in its medium and maximum periods, and a fine not exceeding 200,000 pesos, when the assault is committed with a weapon, or when the offender lays hand upon a person in authority. If none of these circumstances be present, the penalty of prison correctional in its minimum period and a fine not exceeding 100,000 pesos shall be imposed, as amended by RA 10951, August 29, 2017. Article 149. Indirect assaults. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 100,000 pesos shall be imposed upon any person who shall make use of force or intimidation upon any person coming to the aid of the authorities of their agents on occasion of the commission of any of the crimes defined in the next preceding article, as amended by R.A. 10951, August 29, 2017. Article 150. Disobedience to summons issued by Congress, its committees or subcommittees, by the constitutional commissions, its committees, subcommittees, or divisions. The penalty of arresto mayor and a fine ranging from 40,000 pesos to 200,000 pesos, or both, such fine and imprisonment shall be imposed upon any person who, having been duly summoned to attend as a witness before Congress, its special or standing committees and subcommittees, the constitutional commissions, and its committees, subcommittees, or divisions, or before any commission or committee chairman or member authorized to summon witnesses, refuses without legal excuse to obey such summons or being present before any such legislative or constitutional body or official, refuses to be sworn or placed under affirmation, or to answer any legal inquiry, or to produce any books, papers, documents, or records in his possession, when required by them to do so in the exercise of their functions. The same penalty shall be imposed upon any person who shall restrain another from attending as a witness, or who shall induce disobedience to summons or refusal to be sworn by any such body or official, as amended by R.A. 10951, August 29, 2017. Article 151. Resistance and disobedience to a person in authority or the agents of such person. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon any person who do not, being included in the provisions of the preceding articles, shall resist or seriously disobey any person in authority or the agents of such person while engaged in the performance of official duties. When the disobedience to an agent of a person in authority is not of a serious nature, the penalty of arresto menor or a fine ranging from 2,000 pesos to 20,000 pesos shall be imposed upon the offender, as amended by R.A. 10951, August 29, 2017. Article 152. Persons in authority and agents of persons in authority who shall be deemed as such, asterisk, deemed, modified by Section 388 of the Local Government Code, which states, Section 388, persons in authority for purposes of the revised Penal Code, the punong barangay, sangguniang barangay, members and members of the lupong tagapamayapa in each barangay shall be deemed as persons in authority in their jurisdictions, while other barangay officials and members who may be designated by law or ordinance and charged with the maintenance of public order, protection and security of life and property, or the maintenance of a desirable and balanced environment, and any barangay member who comes to the aid of persons in authority shall be deemed agents of persons in authority. Continuation of Article 152. In applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board, or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed a person in authority. A person who by direct provision of law, or by election, or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property, such as a barrio captain, barrio councilman, barrio policeman and barangay leader, and any person who comes to the aid of persons in authority shall be deemed an agent of a person in authority. In applying the provisions of Articles 148 and 151 of this Code, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges and universities, and lawyers in the actual performance of their professional duties, or on the occasion of such performance, shall be deemed person in authority. BP 873, June 12, 1985. Chapter 5. Public Disorders. Article 153. Tumults and other disturbances of public order. Tumultuous, disturbance, or interruption liable to cause disturbance. The penalty of arresto mayor in its medium period to prison correctional in its minimum period, and a fine not exceeding 200,000 pesos shall be imposed upon any person who shall cause any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions, or gatherings, or peaceful meetings, if the act is not included in the provisions of Article 131 and 132. The penalty next higher in degree shall be imposed upon persons causing any disturbance or interruption of a tumultuous character. The disturbance or interruption shall be deemed to be tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The penalty of arresto mayor shall be imposed upon any person who in any meeting, association, or public place shall make any outcry tending to incite rebellion or sedition, or in such place shall display placards or emblems which provoke a disturbance of the public order. The penalty of arresto menor and a fine not to exceed 40,000 pesos shall be imposed upon these persons who, in violation of the provisions contained in the last clause of Article 85, shall bury with pomp the body of a person who has been legally executed. Article 154. Unlawful use of means of publication and unlawful utterances. The penalty of arresto mayor and a fine ranging from 40,000 pesos to 200,000 pesos shall be imposed upon any person who, by means of printing, lithography, or any other means of publication, shall publish or cause to be published as news any false news which may endanger the public order, or cause damage to the interest or credit of the state. Number 2. Any person who by the same means, or by words, utterances, or speeches, shall encourage disobedience to the law or to the constituted authorities, or praise, justify, or extol any act punished by law. Number 3. Any person who shall maliciously publish, or cause to be published, any official resolution or document without proper authority, or before they have been published officially, or 4. Any person who shall print, publish, or distribute, or cause to be printed, published, or distributed books, pamphlets, periodicals, or leaflets which do not bear the real printer's name, or which are classified as anonymous, as amended by R.A. 10951, August 29, 2017. Article 155. Alarms and Scandals. The penalty of arresto menor, or a fine not exceeding 40,000 pesos, shall be imposed upon 1. Any person who, within any town or public place, shall discharge any firearm, rocket, firecracker, or other explosives calculated to cause alarm or danger. Number 2. Any person who shall instigate or take an active part in any charivari or other disorderly meeting, offensive to another, or prejudicial to public tranquillity. 3. Any person who, while wandering about at night, or while engaged in any other nocturnal amusements, shall disturb the public peace, or 4. Any person who, while intoxicated or otherwise, shall cause any disturbance or scandal in public places, provided that the circumstances of the case shall not make the provisions of Article 153 applicable. Article 156. Delivering prisons from jail. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon any person who shall remove from any jail or penal establishment any person confined therein, or shall help the escape of such person by means of violence, intimidation, or bribery. If other means are used, the penalty of arresto mayor shall be imposed. If the escape of the prisoner shall take place outside of said establishments by taking the guards by surprise, the same penalties shall be imposed in their minimum period. Chapter 6. Evasion of service of sentence. Article 157. Evasion of service of sentence. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any convict who shall evade service in his sentence by escaping during the term of his imprisonment by reason of final judgment. However, if such evasion or escape shall have taken place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, or floors, or by using picklocks, false keys, disguise, deceit, violence or intimidation, or through connivance with other convicts or employees of the penal institution, the penalty shall be prison correctional in its maximum period. Article 158. Evasion of service of sentence on the occasion of disorders, conflagrations, earthquakes, or other calamities. A convict who shall evade the service of his sentence by leaving the penal institution where he shall have been confined on the occasion of disorder resulting from a conflagration, earthquake, explosion, or similar catastrophe, or during a mutiny in which he has not participated, shall suffer an increase of 1/5 of the time still remaining to be served under the original sentence, which in no case shall exceed 6 months, if he shall fail to give himself up to the authorities within 48 hours following the issuance of a proclamation by the Chief Executive announcing the passing away of such calamity. Convicts who, under the circumstances mentioned in the preceding paragraph, shall give themselves up to the authorities within the above-mentioned period of 48 hours shall be entitled to the deduction provided in Article 98. Article 159. Other cases of evasion of service of sentence. The penalty of prison correctional in its minimum period shall be imposed upon the convict who, having been granted conditional pardon by the Chief Executive, shall violate any of the conditions of such pardon. However, if the penalty remitted by the granting of such pardon be higher than 6 years, the convict shall then suffer the unexpired portion of his original sentence. Article 160. Commission of another crime during service of penalty imposed for another previous offense. Penalty. Besides the provisions of Rule 5 of Article 62, any person who shall commit a felony after having been convicted by final judgment, before beginning to serve such sentence, or while serving the same, shall be punished by the maximum period of the penalty prescribed by law for the new felony. Any convict of the class referred to in this article, who is not a habitual criminal, shall be pardoned at the age of 70 years, if he shall have already served out his original sentence, or when he shall complete it after reaching said age, unless by reason of his conduct or other circumstances he shall not be worthy of such clemency. Let me include an important discussion on this article. Quasi-recidivism will be appreciated regardless of whether the previous crime, for which an accused is serving sentence at the time of the commission of the crimes charged, falls under the revised penal code or under special law, People v. Alicia. But the present crime must be a felony, punishable under the revised penal code, or an offense punishable under special law, which adopts the technical nomenclature of the penalties of the revised penal code. So for a quasi-recidivism to be present, second crime must be a violation of the revised penal code. One who committed illegal possession of loose firearm while serving sentence for theft is a quasi-recidivist, although Court of Appeals Justice Luis Reyes and Justice Regalado opine that the second crime must be a felony to appreciate quasi-recidivism because Article 160 speaks of a felony. The Supreme Court in People v. Salazar, GR number 98060, January 27, 1997, appreciated quasi-recidivism against the accused who committed a malum prohibitum under RA 6425, the old dangerous drugs law, because this law adopts the technical nomenclature of the penalty under the revised penal code. Since RA 10051, which punishes illegal possession of loose firearm, adopts the technical nomenclature of penalties of the revised penal code, Article 160 of the Code on quasi-recidivism shall be applied in the imposition of penalty under RA number 10591, 2012, bar exam. There is quasi-recidivism where the convicted prisoner killed the victim inside the New Bilibid prison, People v. Alvis. Or, number 2, where the convicted prisoner escaped from a penal colony and then committed robbery with homicide, People v. Britannia. For habitual delinquency, a habitual delinquent is a person who, within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification, is found guilty of any of the said crimes a third time or oftener. The law imposes an additional penalty based on the criminal propensity of the accused apart from the provided by law for the last crime for which he is found guilty. Habitual delinquency is not, however, a crime in itself. It is only a factor in determining the total penalty. In fact, the provision on habitual delinquency is found in Article 62 of the Revised Penal Code on application of penalties and not in Book 2 thereof, which defines felonies. One who is convicted of robbery with homicide and was previously convicted for theft 3 times is a recidivist and habitual delinquent at the same time. These habitual delinquency crimes are embraced in the same title of the Revised Penal Code, on crimes against property. Both circumstances of recidivism and habitual delinquency shall be appreciated against him, since the effects thereof are not inconsistent with each other. The effects of recidivism is the application of the penalty for theft in its maximum period, while the effects of habitual delinquency is the imposition of a penalty in addition to the principal penalty for theft. However, while recidivism will aggravate the principal penalty for theft, it cannot aggravate the additional penalty for habitual delinquency because recidivism is inherent in habitual delinquency. People v. Tolentino, GR number 48740. A convict can be a habitual delinquent without being a recidivist. Not all habitual delinquency crimes are embraced in the same title of the Revised Penal Code, such as theft, falsification, and serious physical injuries. If the habitual delinquency crimes are not embraced within the same title, the convict is a habitual delinquent, but not a recidivist. On the other hand, a convict can be a recidivist without being a habitual delinquent. One who is convicted of theft, estafa, and robbery is a recidivist because these crimes are embraced in the title of the Revised Penal Code on crimes against property. However, he is not a habitual delinquent if the interval of time between his last release or conviction and present conviction is more than 10 years. One who is convicted of acts of lasciviousness, seduction, and abduction is a recidivist because these crimes are embraced in the title of the revised Penal Code on crimes against chastity, but he is not a habitual delinquent since they are not habitual delinquency crimes. Lifted from 2014 bar exam. Article 161, counterfeiting the Great Seal of the Government of the Philippine Islands, forging the signature or stamp of the Chief Executive. The penalty of reclusion temporal shall be imposed upon any person who shall forge the Great Seal of the Government of the Philippine Islands or the signature or stamp of the Chief Executive. Article 162, using forged signature or counterfeit seal or stamps. The penalty of prison mayor shall be imposed upon any person who shall knowingly make use of the counterfeit seal or forged signature or stamp mentioned in the preceding article. Article 163, making and importing and uttering false coins. Any person who makes, imports, or utters false coins in connivance with counterfeiters or importers shall suffer 1. Prison correctional in its minimum and medium periods, and a fine not to exceed 400,000 pesos. If the counterfeited coins be any of the coinage of the Philippines. 2. Prison correctional in its minimum period, and a fine not to exceed 200,000 pesos if the counterfeited coin be currency of a foreign country. Article 164, mutilation of coins, importation and utterance of mutilated coins. The penalty of prison correctional in its minimum period and a fine not to exceed 400,000 pesos shall be imposed upon any person who shall mutilate coins of the legal currency of the Philippines or import or other mutilated current coins or in connivance with mutilators or importers. Article 165, selling of false or mutilated coin without connivance. Any person who knowingly, although without the connivance mentioned in the preceding articles, shall possess false or mutilated coin with intent to utter the same, or shall actually utter such coin, shall suffer a penalty lower by 1 degree than that prescribed in said articles. Article 166, forging treasury or banknotes or other documents payable to bearer, importing and uttering such false or forged notes and documents. The forging or falsification of treasury or bank notes or certificates or other obligations and securities payable to bearer, and the importation and uttering in connivance with forgers or importers of such false or forged obligations or notes shall be punished as follows. 1. By reclusion temporal in its minimum period, and a fine not to exceed 2 million pesos if the document which has been falsified, counterfeited, or altered is an obligation or security of the Philippines. The words obligation or security of the Philippines shall mean all bonds, certificates of indebtedness, national banknotes, coupons, Philippine notes, treasury notes, fractional notes, certificates of deposits, bills, checks, or drafts for money drawn by or upon authorized officers of the Philippines and other representatives of value of whatever denomination, which have been or may be issued under any act of Congress. 2. By prison mayor in its maximum period and a fine not to exceed 1 million pesos if the falsified or altered document is a circulating note issued by any banking association duly authorized by law to issue the same. 3. By prison mayor in its medium period and a fine not to exceed 1 million pesos if the falsified or counterfeited document was issued by a foreign government. 4. By prison mayor in its minimum period and a fine not to exceed 400,000 pesos when the forged or altered document is a circulating note or bill issued by a foreign bank duly authorized thereof. Article 167, counterfeiting, importing, and uttering instruments not payable to bearer. Any person who shall forge, import, or utter in connivance with the forgers or importers, any instrument payable to order, or other document of credit not payable to bearer, shall suffer the penalties of prison correctional in its medium and maximum periods, and a fine not exceeding 1,200,000 pesos, as amended by RA 10951, August 29, 2017. Article 168. Illegal possession and use of false treasury or bank notes and other instruments of credit. Unless the act be one of those coming under the provisions of any of the preceding articles, any person who shall knowingly use or have in his possession, with intent to use, any of the false or falsified instruments referred to in this section shall suffer the penalty next lower in degree than that prescribed in said articles. Article 169. How forgery is committed. The forgery referred to in this section may be committed by any of the following means: by giving to a treasury or bank note or any instrument payable to bearer, or to order mentioned therein, the appearance of a true and genuine document. Number 2. By erasing, substituting, counterfeiting, or altering by any means the figures, letters, words, or signs contained therein. Article 170. Falsification of legislative documents. The penalty of prison correctional in its maximum period, and a fine not exceeding 1,200,000 pesos, shall be imposed upon any person who, without proper authority, therefore, alters any bill, resolution, or ordinance enacted, or approved, or pending approval by either House of Congress or any provincial board or municipal council. Article 171. Falsification by public officer, employee, or notary, or ecclesiastic minister. The penalty of prison mayor and a fine not to exceed 1,000,000 pesos shall be imposed upon any public officer, employee, or notary who, taking advantage of his official position, shall falsify a document by committing any of the following acts: 1. Counterfeiting or imitating any handwriting, signature, or rubric. Number 2. Causing it to appear that persons have participated in any act or proceeding when they did not, in fact, so participate. Number 3. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. Number 4. Making untruthful statements in a narration of facts. Number 5. Altering true dates. Number 6. Making any alteration or intercalation in a genuine document which changes its meaning. Number 7. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to or different from that of the genuine original. Or 8. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. The same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs of this article, with respect to any record or document of such character that its falsification may affect the civil status of persons. Article 172. Falsification by private individual and use of falsified documents. The penalty of prison correctional in its medium and maximum periods, and a fine of not more than 1,000,000 pesos shall be imposed upon 1. Any private individual who shall commit any of the falsifications enumerated in the next preceding article in any public or official document or letter of exchange or any other kind of commercial document. Number 2. Any person who, to the damage of a third party, or which they intend to cause such damage, shall in any private document commit any of the acts of falsification enumerated in the next preceding article. And 3. Any person who shall knowingly introduce in evidence in any judicial proceeding or to the damage of another, or who, with the intent to cause such damage, shall use any of the false documents embraced in the next preceding article, or in any of the foregoing subdivisions of this article, shall be punished by the penalty next lower in degree. Insert 4 kinds of documents under the RPC. Private document, a deed between private individuals by which something is proved, evidence, or set forth, and for which a notary public or one authorized to administer oath has not intervened. Private documents can become public document. Public document, a private document that has been notarized or made part of the public record, or intended at the outset to become part of a public record, like official receipts from private contractors for purchases of equipment by a public office. Official document required by law to be issued or one issued in the performance of official duty. Commercial document, one which complies with mercantile laws. Also, good faith is a defense in falsification. Damage or intent to cause damage is not an element of falsification under Articles 171 and 172. It is the violation of the faith or trust of the public and the destruction of the truth as solemnly proclaimed in the document that is penalized. Intent to gain or cause injury is immaterial. Kaubang versus CA.